The Supreme Court heard oral arguments on Alabama's voting map on Tuesday. The hearing had massive implications to the Voting Rights Act and its protections against racially discriminatory congressional maps. New Justice Ketanji Brown Jackson came out strongly against dealing a blow to the Voting Rights Act during her second day on the bench. Justice Jackson sharply criticized Alabama Solicitor General Edmund LaCour, saying his premise was false and that race has, quote, already infused the voting system. The Supreme Court will rule on the case in the coming months.
Similarly, if you challenge multi-member districts and you replace them with neutral single-member districts, no one's worse off on account of race. But if you have a neutral plan and someone comes in and upsets it to racially gerrymandered in favor of one racial group, well, necessarily you're going to be harming some other group on account of race.
But why are you saying it's a neutral plan, counsel? I don't understand. The Jingles preconditions are designed to establish that there may actually be race discrimination working in this particular situation, right? We have, as Justice Kagan pointed out, not just the initial hypothesis, which, by the way, is how I look at the first step. I don't think the first step is, creating some sort of a comparator or anything of the sort. The first step is a burden on the plaintiff, on the challenger, to show that their hypothesis that another district could be drawn, another majority-minority district, is even feasible given the empirical numbers in the situation. All right, so if we accept that, that's step number one, and it contains an assessment of things like racial segregation in housing, because you have to have enough of these people pushed in, compacted in this district, right? So we already have this idea that there's some problem because we have racial segregation in housing at step one. Then step two is asking, do we have a problem in the sense that people are voting in racially polarized ways? Step three is also that kind of dynamic. Do we have a situation in which the majority group is always voting in the same way? These are really tough things to establish, and collectively, they show that it's not neutral, the situation that we are approaching in this situation. We're talking about a situation in which race has already infused the voting system. So can you help me understand why you think that the world of race-blind redistricting is really the starting point in this situation?
Well, let's think about why you have a compactness inquiry in the first place. It's to make sure that no one's being harmed on account of a lack of compactness. And that's why traditional districting principles are part of this inquiry too. So no one's being harmed.
I don't think so. I think it's to show that you have racial segregation in housing happening in this situation, that you have enough people who are in marginalized groups that another district is possible. And why is that happening? Because people are being segregated in effect, as Justice Kagan pointed out, right? We're not talking about intent. We're talking about the effect of what's happening on the ground in these jurisdictions.
2 points. First, on the segregation point, if there really was that compact, segregated part of Alabama to draw that second black district, they wouldn't have had to split Mobile for the first time ever, gone 170 miles northeast up to Montgomery, and then dipped 100 miles to the southeast to Dothan, Alabama.
Okay, so